All right, 25 minutes before 11 o'clock. John Fuller is here. This is the segment of the week called Legally Yours. It's called that because John is here to give you some legal advice if you need it. John is an attorney at the law firm of Fuller and Fuller here in Ocala. The other Fuller is his wife, Janet, and he brings us the information we need every week, and he also illustrates why people go to John to be their attorney, because you obviously have a way of making your point. Good morning, John. How you doing?
Good morning, Larry. Thank you, and good morning to our listeners. We are happy to be here to talk about legal issues. Legal advice is, of course, best given when you go and have a personal conference with the lawyer who's going to be representing you, and you give him or her all of the details and have an opportunity to discuss it in specifics. But we enjoy very much the questions that we get and the opportunities that we have to discuss general principles of law and to encourage people to protect their legal rights and to be aware of their legal rights. So it's a fun story, a fun show, and we have some wonderful listeners, and we appreciate them very much.
So your ears might have been burning this morning because we were talking about April Fool's jokes that went awry, and could you sue somebody for an April Fool's joke? I guess it depends on how bad somebody might have been damaged or
well, you know,
hurt.
we say every week on this show that the answer to so many things in the law depends upon the factual detail. You know, there's thousands of appellate court decisions that revolve around the unique facts of each case. And we've talked about the elements of different causes of action. One of the issues is an issue called foreseeability. And I suspect if you gave somebody rat poisoning in a cookie, thinking that would be a good April Fool's joke, that probably would not be a defense to an act like that. So April Fool jokes that are verbal, they're cute, and we've all heard of great pranks. And some people are very gifted and imaginative when it comes to those things. But things that cause injury or that cause undue distress. You call someone up and tell them that their loved one's just been killed in a tragic accident.
Oh, boy, don't do that.
And all of a sudden that individual goes into coronary arrest, faints, passes out, and dies or has severe brain damage because of a heart attack, because of emotional distress. And then you say, wait, April Fool's not gonna carry the day, I'm afraid. So like many things, I'm always amazed that the answers don't have to lie in the law. They just lie in good common sense.
Common sense,
So I think that's probably as much as we can cover on the April Fool causes of action.
You know, I heard a story that you can get a citation, and this would be a New York City specific thing, but if you hold the door open on the subway, thus causing the subway to not move, or like if you're like you do for an elevator, that you could get a citation. The police can give you a ticket, and you have to go to court.
Yeah, they could. You know, if the act is one of destruction, malicious mischief, intentional foreseeable harm that you cause the person that is the recipient of what you perceive as a good-natured joke or prank, it still has to be measured by the impact that it has, and there are laws on the books that prevent people from outrageous misconduct, whether done under the guise of humor or whether done in anger or just out of malicious mischief.
Do you know what I didn't understand? In the news last week, there was this millionaire, and I guess they did a special on HBO, and he went to the bathroom, and he still had the microphone on, and he basically admitted to some murders that had happened around him, but not to anybody. He was kind of mumbling to himself in the bathroom. And so then they arrested him. I can't remember the guy's name now.
What kind of microphone was it?
It was like he was doing a TV show, and he still had it on.
Oh, okay.
Still had it turned on. So anyway, but it was not admissible in court. And so the general question, not about that specific case, obviously, but in general, is that something that attorneys will fight for or against? Is that video or audio evidence that somebody might have collected?
Absolutely, and one of the heart of criminal defense work and a large portion of what criminal defense lawyers do is to argue whether or not evidence that may be damaging to their client is admissible under our rules of evidence. And they are very specific, very complex rules of evidence. And then, as a more important protection and overlay, we have our Bill of Rights protections in the Constitution. And that includes the right to privacy. It includes the right to remain silent, not to provide evidence that would intend to incriminate you. And so if you are saying something with a reasonable expectation of privacy, and somebody inadvertently or clandestinely or inappropriately tapes or records that, then you have an argument. Wiretaps. You can't get a wiretap without a court order.
Right.
Now, there's some exceptions to that under the Homeland Security Act, and that's way beyond the scope of what I want to discuss today in general terms.
Right.
But we have a constitutional right that protects that. And so it all boils down to, was there an expectation of privacy? He's in the bathroom.
Right. In that
he didn't
case,
know
yeah.
he had the microphone on.
Wow.
He didn't know that anybody else could be hearing. So certainly you would challenge the admissibility of that evidence with a motion to suppress. And some judge would decide whether or not it fell under any exception that would allow it in, or whether it should be excluded. We have trials that are based upon very rigid, structured rules. Trials are not a free-for-all. You can go talk to the press, you can talk to your neighbor, you can talk to someone, and you can tell them the story, putting in whatever you want to. But what goes to a jury to be heard has to pass legal standards that it is admissible evidence. And those standards are based upon trying to secure and protect that the evidence that the jury hears is reliable, it's believable, it is something that is based in fact. So you can't go to court and testify to things like hearsay. Now, there are many exceptions to the hearsay rule, but generally, you can't testify to an out-of-court declaration to prove the truth of a material fact in a lawsuit. You can't speculate about what happened.
Well, that makes sense.
And you can't offer an opinion unless you're qualified as an expert witness. You can't come into court and say, I think that guy's crazy. I could look in his eyes and you could just tell he was nuts.
Right.
Well, if that's not going to be admissible. You can go and challenge somebody's competency, but it has to be done under certain rigid rules.
So when there's a jury involved, do you ever bring something up that the judge might say, scratch that from the record, but the jury has already heard it? How do they?
Well, there are rules to control that. Certainly you have a right to litigate a disputed issue, because that's how the law gets changed, is when if there's a law that says you can't do X, but you challenge it, and then ultimately they change the law so that X can be done. But you have to do it in the correct way. Generally in trials, disputed evidence is known about before the trial begins, before the jury's ever summoned to the courthouse. And those issues are dealt with by the judge in pretrial motions, a motion to suppress the evidence. If it's not suppressed, then motions in limine to limit the testimony from coming in before the jury. Then if the evidence is offered, an objection. Then the jury is taken out of the courtroom and the person is required to proffer that evidence, which means to put it on the record before the judge without the jury hearing it. And then you renew your objection, you renew your motion in limine, and the judge rules again. Then if he rules that all that should come in despite that, and it does come in, then that's appealable to the appellate court, and the appellate court will then review that record, review that testimony, the circumstances under which that testimony was obtained, and then rule whether the trial judge committed reversible error or not. The theory under the law is that you can't convict somebody in a criminal case with what the Supreme Court has called the fruit of the poisoned tree. If the evidence is obtained in an unlawful matter, even if the evidence is conclusive and probative and would prove the guilt of the defendant, if it was unlawfully obtained, it is excluded or should be excluded as what the Supreme Court has said, the fruit of the poison tree. The main thing is the end doesn't justify the means. The rules are there to ensure that everybody gets a fair trial.
Really, really. The phone number is 622-9622 if you'd like to speak to John Fuller. We'll take a little break and be right back. If you call right now, you'll be on hold about a minute and a half. So we'll take that little break, catch up on the weather, and we'll be right back with John Fuller. The number again, 622-9622. We'll be right back.
The weather is brought to you by myfwc.com. Safe boating is no accident. For today, a nice one with intervals of clouds and sunshine at an afternoon high of 81 to 85. Tonight, partly cloudy skies, lows ranging from 60 inland to about 65 along the coast. For tomorrow, some sunshine with a shower or thunderstorm possible in the afternoon, high 80 to 84. On Friday, mostly sunny and warm, the high 82 to 86. From the Florida Weather Center, I'm meteorologist Joe Lundberg.
Are you wasting hundreds or thousands of dollars on termite retreat fees? If you're not with Turner Pest Control, you probably are. Turner Pest Control offers the industry's only termite and pest control package that never charges retreat fees, ever. You can get started today for only $99. This is a value of $500 or more. This includes treatments, installation of monitoring stations, quarterly pest control, and a lifetime guarantee, all for an unbelievable low $99. Even if you have another pest control provider, visit turnerpest.com to find out how you can avoid paying those high termite retreat fees.
All right, 12 minutes before 11 o'clock. Thank you for tuning in. John Fuller is here from the law firm of Fuller & Fuller. He is an attorney, obviously, and he's answering your legal questions. And the phone line is 622-9622, and you do have a call, John. Good morning. Thank you for waiting. You're on the air with John Fuller.
Good morning.
Hi, I'm David.
It's nice to talk to you, David. Thank you for taking the time to call in.
Yes, about 15, 20 years ago, down in Fort Lauderdale, my ex-wife put a restraining order on me, and it's one of those permanent ones. And I didn't go through a jury trial. They just put, without any checks or balances, they put this thing on you. And even to this day, my constitutional rights are violated. Why don't they make the laws where after 5 years, if you haven't bothered the woman or anything, it should automatically be removed because you're no threat? And 3 times I went down there and to Fort Lauderdale to petition the court, and because she says that she's still afraid of me, they still keep it on me. This is not right. This is not constitutional, and it's against the Bill of Rights. Why can't the lawmakers change this law?
Are you talking about Florida?
Yes.
Well, first of all, constitutionally, you do have a due process protection because a person cannot get a permanent injunction against another for domestic violence without having a hearing and evidentiary testimony before a court decided by a court. If the court concludes that there is sufficient evidence to believe that the alleged victim is still in danger or has a reasonable fear for his or her safety, they will maintain the injunction in place. That is an appealable ruling by the court. Now, the appeal would be on the abuse of discretion, and I certainly tell you that's a difficult standard to get a judge reversed on, but that is a legal remedy. So they are protections and checks and balances. The other thing is that, as you apparently have already experienced, you do have the right at any time to file a motion to dissolve the injunction on the grounds that there's no longer any basis of it because of the passage of time, whatever the activity that led to the initial entry of the injunction is so remote in time as to have no current probative value, and put that back before the judge. And if the judge, and you need to put on some evidence, you need to maybe go have a conference with a mental health advisor who does an anger management assessment and comes in and testifies that you do not have any tendencies to be dangerous to other people and that you are in full command of your personality traits and your temper. And I would look to some expert testimony on that.
I did that. But no matter what, when my ex-wife says that she's still afraid of me, the judge still doesn't remove it. No matter, even if I did all that.
Well, did you have a lawyer?
No.
Well, I would go consult with a lawyer who handles domestic violence cases, and I would see what he could do. And then, if you don't get relief at the trial level, then consider taking an appeal.
I think it's unconstitutional against the Bill of Rights.
I understand your thought. I appreciate you calling. I encourage you to go seek counsel with someone who handles domestic violence situations.
Do you handle that? Do you
No,
handle
sir.
that?
No. But I would encourage you to do that.
Thank you, sir.
Thanks for calling.
Wow. So how would he find the proper attorney for that?
You can call the Florida Bar 800 number, who will refer lawyers. It's 800-342-8011. You can check online under domestic violence attorneys in this geographical area, and they list people who handle domestic violence cases. And it's not hard to find a lawyer. There are nearly 100,000 of them in the state of Florida, so they're pretty easy to find if you want to do it. And
is he in violation of the law if he's within the distance that was restricted of him?
Well, I don't know I don't know what the injunction said, but if the injunction is still active and in force, he really must be very meticulous and careful in complying with it without any violation of it, because that could put him in extreme prejudice.
Yeah, and then he would definitely need a lawyer. I mean, if he just went to the grocery store and happened to be with, let's say it was a 5-mile limit or something.
Well, most of the time you don't see 5-mile limits. You see 300 feet or
okay. I didn't realize that. I didn't realize
100 feet, So, I mean, there's so many details that we don't know about that case.
That was an interesting call.
And you don't know what the original alleged act was.
Mm-hmm.
Was it someone just in a domestic quarrel who pushed someone up against a wall? Or was it somebody who went out and hired a hitman and showed up with a machete and, attempted to do severe violence? And I'm certainly not suggesting this about our caller, but I'm saying that the spectrum of the facts are all over the place. And the court has to weigh and has to hear the evidence and then decide the believability. Is it factually reasonable that does a person have a reasonable basis in fact to continue to be in fear of their safety? Right. And I don't know what the facts are that the judge heard, so you can't second guess whether a judge was right or not. But constitutionally, you have a right to a hearing and you have a right to an appeal. That's how the Constitution protects you. The fact that you disagree with the judge, you take an appeal. If you lose the appeal, then that's the ruling
That's what
that
you
you
have
have
to
to abide by,
But-
and that's the way our system works.
It did sound like a lawyer would be the best solution.
Well, he's
for
failed
him.
2 or 3 times
Yeah,
trying to
yeah,
be his own
right,
lawyer,
right,
and
right.
obviously you're not making much progress, and there needs to be somebody look at it from a different perspective. There may not be anything you could do. He may have done everything absolutely right. Certainly, many people are capable of representing themselves in court cases, and there are a lot of forms now that are designed to help people in the family law area fill out the form and go to court without the necessity of a lawyer. But if you want to get relief, you've been unable to get it as representing yourself as a pro se litigant, then you certainly are better off seeking counsel who will go over the specifics of your case
Wow.
and then prepare your case. So.
Interesting case for sure. The phone line is open if you want to call John. The number is 622-9622. Just so you know, today's April 1st. Sometimes John can't be here because he's in court, but today he is here live. If your calendar says April 1st, then you're listening on the same day that he's broadcasting. Wow, that was an interesting one. Something came up, not as serious as that, but if you're in an automobile accident and you're rear-ended, are you automatically not at fault? Is the guy behind you always at fault? Or?
Well, I don't think you can deal in absolutes, but when someone collides with you from the back, there's generally a presumption that the person who hit the car in front is negligent. But there are defenses to that. If someone abruptly stopped without warning and for no reason.
Right.
I had a case not too long ago. I wasn't involved with it, but I heard about it, where an older driver was going very slow and came to an abrupt stop at a green light. And the car behind them looked up, saw the green light, was going with the flow of traffic, and all of a sudden, the person stopped at a green light, and there was a little tiny fender bender. Well, you would have a defense that the person up front who improperly stopped at a green light was a causative factor in the rear end collision.
Yeah.
If you are parked behind somebody and they're in front of you, and for whatever reason they put their car in park while they're waiting for the traffic light to change, or while they're waiting to go through the drive-in at the bank or something like that, and when they get ready to go, they accidentally put it in reverse instead of putting it in drive, and they step on the accelerator and they accelerate backwards, even though the car in back collided with the car in front. That's more a case of improper backing, I think. But no, generally, if you collide with the car that stopped in front of you, negligence is pretty well established and presumed, because you're obligated to drive carefully and pay attention to all of the circumstances around you, and the road and the speed and the traffic control devices, the width, the grade, the curve, and all attendant circumstances is the exact language from the statute.
John, we're out of time.
Well, it's been fun. I appreciate our callers calling.
How do we get a hold of you? What's your number?
We're at the law firm of Fuller and Fuller, and the local number is 352-547-4292. Our toll-free number is 855-534-2565.
And is your website ocala-lawyer.com?
Yes, ocala-lawyer.com.
Okay. Thank you, John. Thank you for what you do. And thank
Always
you
fun.
for doing the show. We'll take a little break. We'll be right back.
Here's a way for you to have some fun and at the same time support Team WOCA.